Good afternoon. Thank you all for being here. I appreciate the fact that this is a very busy time for everyone in higher education, and your time is valuable. And so we hope to make this a valuable hour of your afternoon. So again, thank you for being with us. Before we get started, I wanted to give you a little information on a program we're working on with Title IX Solutions. We are currently putting together a pool or panel of mediators and arbitrators to facilitate informal resolutions for colleges and universities throughout the United States. These are all experienced mediators and arbitrators. They're active or retired attorneys, former judges, a broad range of experience in mediations, and they will also have training and background in Title IX prior to their starting the mediation services for schools this fall. We will follow up with additional information on that within the next couple of weeks by email as well as on our website. Several of those individuals are also available to serve as decision makers for the hearing process for colleges throughout the country. And we will provide additional information on that as well. I know that many schools have contacted us over the past several weeks since the new final regulations came out, asking if we were available to provide decision makers or knew of groups that were willing to take that on because of the apparent preference to bring in outsiders for that role rather than using campus-based decision makers for the hearing process. So we will keep you apprised. Our speaker today is my friend Rob Litz. Rob is the president of US Arbitration and Mediation, which is an arbitration and mediation service based out of St. Louis, but handling mediation throughout the United States. They have a panel of over 50 mediators, arbitrators, who cover all types of litigation topics, ranging from product liability to employment issues, and they're very experienced, every one of them. Rob personally was formerly a civil litigator, but he has been handling mediations for more than 20 years. He is an instructor at the Washington University School of Law in St. Louis. He's a frequent lecturer throughout the country, as well as an author on various topics related to mediation and arbitration. We're very pleased to have Rob joining us today. So welcome, Rob.
Pat, thank you so much, and I really appreciate the invitation. Pat and Adrian forwarded a copy of the list of attendees today, and it's amazing. We have folks from coast to coast, north to south, I think exceeding 250 attendees. So welcome to all of you. I know this is a new area in the Title IX world, dealing with informal resolution. I know it's all of about a page or so in the new regs, somewhere just past page 2000 or so. And it creates an opportunity to resolve these types of complaints outside of a normal hearing process. And we thought we would take this hour to talk about those various options and walk through the various processes. Next slide. So Pat had asked me to at least touch on what are some of the common types of informal resolution, and this slide gives us a little bit of the continuum. On the right side is adjudication, and in the Title IX world, we're looking at decisions before the hearing officer or a decision maker. In civil litigation, it's what a judge or jury would decide. At the other end of the spectrum is where parties to a dispute can themselves work out the problem through direct negotiation. And then in the middle are these various forms of dispute resolution that involves a neutral third party either assisting parties to settle, which is on the mediation area, or if they cannot resolve through mediation, through the arbitration area. And we'll talk a little bit more detail in just a few minutes. So our next slide. They are completely different. And in fact, when I started getting into this alternative dispute resolution area in the late 1980s and early 1990s, it was not surprising to find practicing lawyers that didn't know the difference between mediation and arbitration. So the next slide, I'll go into what is mediation. So mediation is the process where one of us, as a neutral third party who has no relationship, no conflict of interest, no bias, assisting the parties to try to reach an agreement between them. And in the Title IX situation, we're looking at a complainant, a respondent, and then the school itself. So oftentimes we'll have two-party mediations, and in this setting, it would be a three-party mediation. It's by consent, and under the new regs, it requires a written agreement between the parties to agree to, instead of going to the formal process, to try to resolve the case with the assistance of a mediator. It is more informal than a hearing process. There's no adjudication. The mediator has no authority to make a decision. In fact, it's each of the three parties who are the decision makers. The process itself is confidential, what goes on during the process, but I make a distinction between the process and what the end result or the agreement that was reached may not be confidential. That is up to the parties. And it's no different than, Pat, the mediations that we have done. Sometimes it's important that the parties have confidentiality, and other times they don't care about whether the information does get out. Next slide, please. The difference between mediation and arbitration, think of the arbitrator as the judge or the home plate umpire who's calling the balls and strikes. He or she will call them like they see them. Their role is not to facilitate a negotiation. They are looking at the facts. They apply the facts to the law and they make a decision. And generally, that decision is binding. It's called an award, an arbitrator's award. And the award, if the parties comply with what the arbitrator ruled, may never be disclosed. But like in a civil case, if one party is ordered to pay another party a certain amount of money and they don't, that could become public through a process in court. But the process of arbitration is guided by two things. One, the written agreement of the parties, and that will look at various things. Things like, will it be one arbitrator or could be a panel of three arbitrators? What are the qualifications of the arbitrator? Where would the hearing take place? So you have the written agreement of the parties, and the other is the rules of arbitration. At U.S. Arbitration Mediation, we have published rules for arbitration. It provides for fairness, opportunity for people to respond to claims, and sets out the administrative process for managing an arbitration case. Next slide, please. There's a third area in the regs and the commentary to the regs that deal with informal resolution. So there is mediation, where the parties are resolving the disputes themselves with the assistance of a mediator, the arbitration where the arbitrator will decide the particular issues, which is more like an adjudication. And the third is restorative justice. Often this is used in community mediation and in schools, and it involves the focus on repairing the harm that was done. And it involves historically the sense of identifying the victim, the offender, and then the community that was affected. And it's a collaborative process so that instead of a normal, let's say, criminal justice issue where the focus is the state pursuing an offender and trying to get justice through punishment, it involves focus on the victim and the harm that was done and trying to create a remedy that the parties can make right the wrong that occurred. So the three, restorative justice, arbitration, mediation, are the three informal resolution processes that are referenced in the new regulations. Next slide, please. So why do folks go to mediation as opposed to just having the matter resolved through the adjudication process? Generally, the parties can come up with a solution, a settlement, if you will, and it can cover things which a judge or a hearing officer could never order. It allows parties to create their own outcome, to be creative. And the process is generally faster and less expensive than going through the formal process. And I think also very important to the process is that it's confidential. The process itself of what's disclosed during a mediation, that someone said, my first demand is X, or the other side's first offer is Y. That's confidential. We're used to that here in the state of Missouri because we have a statute that says what occurs in mediation is confidential, and there are several other states that have that. But one of the things that all of the arbitrations will require in Title IX is a written agreement by all the parties, and generally in that agreement, it'll touch on the requirement for confidentiality. Next slide, please.
Rob, if I can interject here for just a moment. And this is noted in the preamble to the new regulations that one of the motivations for the introduction of informal resolution processes into the Title IX overall process was to allow students to avoid the traumatic experience of going through a full investigation and the hearing process. And as most of us know, there's been much discussion about the rights, both the pros and the cons, related to the rights to cross-examination. So particularly in the Title IX arena, the opportunity to avoid some of the process and the potential trauma of the process of an investigation and formal hearing, I think is a benefit for many students when they're facing a Title IX investigation to choose this alternate route. The other thing I think that we've had several conversations with schools about is the anticipated cost of going through a full formal investigation and hearing, and particularly the requirements now under the new regulations that the school provide an advisor, whether it be an attorney or otherwise, for the parties during the hearing process. And I noticed in reading through the preamble that even the Department of Education estimates that the average time for preparation and participation in a hearing may be up to 60 hours for each attorney. So if you anticipate the cost of paying for one or two, or perhaps with the school, 3 attorneys to go through a 60-hour process, it's a significant potential financial aspect for many institutions. And depending upon the rate and the hours, that could obviously be even more dramatic costs for some schools than others and some incidents than others. So I just wanted to kind of interject that I think this will be a motivation for schools as well as complainants and respondents to consider informal resolution as a way to address a Title IX investigation.
Pat, that's absolutely the perfect time to raise this. And again, the cost in looking at one of these alternative approaches, such as mediation, compared to going through the entire process, is what we do in every mediation. We are comparing what's the alternative. If you're negotiating in a mediation, what's your alternative? You know, in Title IX, it's completing an investigation and going through the formal hearing process. Pat, do I understand that with the opportunity for the parties to have representatives, including attorneys, if they can't afford an attorney, does it fall upon the school, the college or university to advance the funds for those parties?
Yes, yes. The regulation provides that at the hearing level, the school is responsible for providing an advisor without charge or fee to the party.
Okay, so I like to talk about mediation and think of it as a three-legged stool, and it is comparing what's being discussed and analyzing it versus the cost, the time, and the risk to each party if you go forth on the other path, the full hearing path. So for colleges and universities, you could be looking at covering your legal cost through a hearing. Oftentimes that's with outside counsel, as well as paying the cost for the complainant if they are unable to afford a lawyer, and the same thing with the respondent. So cost is an important component. Time is another component. It's not just the timeline between, okay, a mediation may be June 11 and a hearing may not be for a few months, but it's also the time involved for those who were witnesses of the event and preparing them to be witnesses and to solicit the information that they have. Mediation allows the parties to deal with all of the issues and allows them to turn the page on that particular chapter. The other thing is risk. Risk is not just, it may affect the school in a certain way. It may have an impact on publicity. It may have an impact on the reputational risk of the school. So all these things are taken into account when we're looking at mediation and comparing it to the other path of going forward through the formal process. Pat, you mentioned one other thing that I think is worth noting, and that is mediation can happen early on, but my understanding is a formal complaint must be on file before the parties can choose to mediate. Isn't that correct?
Yes, that's the requirement under the regulations.
So what's always interesting to me is how early could you mediate your case? And I think the parties need to at least know the underlying key facts, all the material facts. But I don't know that it requires the full investigation to be concluded. Next slide, please.
And I think as a practical matter, cases can be resolved informally without the complaint being filed. But under the Title IX regulations, that's the triggering point.
And, you know, Pat, when I look back at that continuum of dispute resolution techniques, negotiation was on the left, and that's always available to the parties. Let me spend just a few minutes talking about the mediation process and what's involved. It's a process. Think of the mediator like the Secretary of State who performs the shuttle diplomacy between countries. We generally will have folks in 3 different conference rooms, since this would be a 3-party mediation. But oftentimes we have a joint session, and the joint session with all the parties in one room can take a couple of different types of approaches. One, we're just walking in and we're doing a meet and greet. Who's here? Who do they represent? And identifying the ground rules of how the day may go in terms of process. Oftentimes, we'll sit down around the table and have a conversation about clarifying what are the claims that the complainant has raised, and what are the outline of the defenses that the respondent may have, and what might the viewpoint be of the university based on these kinds of situations. It's important to note this is not what a lawyer would present to a jury in either an opening statement or in a closing argument, certainly in court. I think it is the unique time in the process where a respondent's lawyer or the respondent themselves can look to a complainant and say, we're sorry for what happened. We understand the harm that this has caused, and we are here today to make this right. We have certain things that we're willing to do, and we're going to work hard. We're going to work in good faith to try to get this resolved. Before a mediation happens, oftentimes a complainant is sitting there thinking about what all could occur, and when a respondent, or in a civil case, a defense lawyer walks in the room and has that type of an acknowledgement, it will take the air out of the room. And then all of a sudden, people are working more collaboratively to find a solution that works for all the parties. I'll talk a little bit later about the power of apology, which is a little different than acknowledgement. And after the process of being together, we'll go into separate rooms, and it gives me an opportunity, or the mediator the opportunity, to peel the onion a little bit more, to understand the wants and the needs, the interests of each party. One of my former colleagues at Washington U School of Law used to call it understanding the gin of each side, the goals, interests, and needs. Because when we as mediators walk into that process, we know the least of anyone else there, and we're really only seeing the top of the iceberg. And our goal is to learn what was below the surface, so that we can get a better understanding of what the possibilities might be for resolution. 2 things about process. It would start with the written agreement that we were talking about before, and this is the written agreement to go to mediation. And then if the case is resolved, at the conclusion of that day, the parties would sign an mediated settlement agreement, is our practice. Some people will call it a term sheet. So it has all the material terms of the settlement. Pat, none of us want to have a situation where a client gets cold feet the next morning. We want to be able to reach an agreement and have it be enforced. Next slide, please. So what does it take to prepare for mediation? Like everything else in the world, frankly, it's more about preparation than perhaps the execution of the process itself. Again, the mediator knows nothing about what went on, and the lawyer or representative for the parties, we like to encourage them to provide the mediator with a position paper, sometimes it's called a mediation brief, to give us the background as to what happened and what are the interests and the goals of their particular client. We also want to know things like, have there been some negotiations that have been ongoing? And if so, what was the last offer and what was the last demand? Those types of things. But it also gives the representative the time to explain the strengths of their case. And frankly, good lawyers will also acknowledge the weaknesses of their particular claim. The client and the representative also needs to stop and look at, okay, what's the roadmap that we're going to use? We made a last demand here. We're probably willing to go to another spot. So where are we going to start and where do we want to end up? And I will say this, as much as you want to say, I want to end up with at a certain place, people learn things at mediation. And certain interests, sometimes certain facts will come out at mediation that may cause each side to be more flexible in where they thought their ending point might be. I think it's also helpful from the college and university perspective that if we're talking about mediation versus the full hearing process, what is that process going to cost? How long will it take? And what risk does the organization have? And that's something that you want to rely on your outside counsel or in-house counsel to prepare so that you're going into this with eyes wide open and not to have particular surprises. The last thing I suggest is be open to the process, not to be impatient, because it does take time. I think perhaps the last case I had a matter with Pat a few years ago. It took all day, and frankly, it didn't resolve that day, but a couple of days later. So that could be an 8-hour case. On average, our mediations are about 5 or 6 hours. The case I had a week ago today, we resolved the case in 1 hour and 45 minutes. So it's a process of back and forth. Next slide, please. So part of your preparation is to decide who's going to attend. From the university standpoint, is it is it dean of students, is it Title IX coordinator, to think through who is the person or persons who know most about the situation and have the authority to make decisions. It's not helpful to say, oh, so-and-so who couldn't be here today is the one who has to make the decision. We like having decision makers there, or at least be available by a telephone if need be. The who should not attend is also something that has to be considered. Sometimes you'll have students who will want to have a support system with them. It could be parents, it could be a friend or a member of the clergy. But the who should not attend is someone who is not going to be collaborative in the process. You want folks to assist, to be thoughtful, creative, and the mediation is not a place where someone's going to obtain the pound of flesh. So I think it's always important for parties to think about who should be there to support them, and perhaps who would be the kerosene being poured on the hot fire. Next slide, please. So coming with authority certainly is helpful. I realize that not every university, especially the larger institutions, are going to have the ultimate decision maker there, and that there are levels of authority. But establishing that ahead of time is, I think, important. But as I said overall in the beginning today, having a sense of, if we don't settle at mediation, what might we expect? How much will it cost? How long will it take? And what are my risks? And when I reference in this slide to think about alternatives, if it's not settled, you're thinking about what is the BATNA, the best alternative to a negotiated agreement. So what's your alternative to negotiating an agreement? And if the answer is you're going to take a risk before a hearing officer deciding this at a formal hearing under the new regs, there's cost and there's time and there may be some risk. So those are things to think about prior to the mediation. Next slide. Pat, I thought I'd spend just a few minutes talking about what happens during the mediation process, because every case is a little different, but there are some consistent themes that we see. Oftentimes, mediators and opposing sides will have to deal with various problems. Often we'll say, okay, my job is to figure out who is the problem in the room. Is it the client? Is it the lawyer? If it's the client, what's going on? What's below the surface? And that may mean pulling the lawyer out, having a private conversation with the lawyer. It could be the lawyer is the problem, who may not appreciate the kinds of issues relating to Title IX. It could be the complainant's lawyer could be their first cousin or the neighbor next to their parents who said, yeah, I'll come help do this mediation, and not have an appreciation for the issues. And the same thing with the respondent's attorney or representative, not appreciating what the case issues are. During the mediation, though, it's always helpful for representatives to pull us aside. Maybe we're going to get a cup of coffee. They could say, oh, I'm going to grab some coffee, step out and give a heads up to the mediator or ask us questions. Rob, look, I'm having this issue with my client. Could you help me with? And then fill in the blank. One thing I'll say about every mediation, you're dealing with mediators who are experienced. You're dealing with lawyers who mediate all the time. And in time, those of you from colleges and universities will have experience with the mediation process. So the novice is going to be the complainant and the respondent. They won't understand the process. There are going to be lawyers there, and our job is to help the representatives make this process understandable and comfortable so that we can have a proper dialogue. Next slide, please. So a decision has to be made, frankly, when you're preparing. Do we want to have a joint session with everyone? Or is it a situation where the complainant has just said, look, I cannot be in the same room as the respondent. It just can't happen. But if they can be together, what type of session do we have? And again, this is an opportunity for the representatives to, or the parties themselves, to be able to share. This is what happened to me, the complainant. Here is how my life has changed. Here is my perspective. These are the things I'm thinking about. And the same thing on the respondent side, because they're going to have certain reactions. If folks are represented by counsel, I believe it's in the best interest to ask their clients to speak. Some lawyers won't allow their clients to speak, but I do think it's helpful, because we're all learning information, and we make better decisions when we have more information. The mediator can certainly control the agenda of the joint session. We set the ground rules. One of the things that everyone will hear again, in addition to the agreement to mediate, they will talk about confidentiality in the process. We'll reinforce that during a joint session. We'll talk about confidentiality in a different setting. Many of us will hear information in a caucus, just with one particular party, and mediators work differently. The way I like to work is to tell the parties, look, when there is something you want me to keep in confidence, tell me that, and I'll keep it under my hat. Otherwise, I will use the information that I think I need to help move the parties closer to resolution. And there are times where they'll disclose something to me early on and tell me not to use it unless and until I'm authorized at a later time. And sometimes I need to, I'll ask permission, etc. The mediation is fluid. Sometimes it takes longer than we would like, but it is a process of back and forth, and it gives all the sides the opportunity to maybe learn more information, because frankly, our job is to ask questions, probing questions of each of the parties and their representatives. And sometimes it'll be something to the effect of, gosh, I hear that you're telling me that something happened. Well, what evidence will you use to prove that at the hearing? Because at the end of the day, it's the alternative to your hearing, and you're only as good as what you can prove. So sometimes we'll be making inquiry about proof or evidence, etc. I included this notion about a backward step because sometimes, as Pat mentioned, people may be having a negotiation even before a complaint was filed, and they may have offered to accept a particular remedy, and then they get to mediation and the complaint now is way above, and they've taken this, they're asking for so much more. And the flip side is the respondent may have been offering to do several things, but then when they get to mediation, they pull back. I always caution people about doing that unless some new fact has come into play. Otherwise, it's going to take me an hour or two to get us back to where we were. So let's try to move forward and be collaborative in moving that negotiation and mediation process forward. Next slide, please. So one of the things I think is important in this context, no different than what I have taught my mediation students, it is a unique ability to take your eyes out of your head and look at the situation from the other party's perspectives. If you are the school or the respondent, what's the drama that's happening in the complainant's caucus room? What's going on? And what decisions, or sometimes what drama may be going on in the respondent's room? And then looking at what are the interests, wants, and needs of your schools. How does it jive with your code of conduct? What impact would this have on future claims? How does this impact non-financial issues, reputation, publicity, etc.? The other thing to consider is when making offers and demands, how quickly do you move? Because oftentimes when another party moves very quickly, the other parties are going to think that that's an indication that they really want to settle and may hold fast in that negotiation to things that maybe they would have moved to a more of a middle ground. So you can do what we call the dance in mediation, but at some point it's important to recognize that it's closing time, and let's reach an agreement. Next slide. So I mentioned before, at the initial joint session, there is an opportunity for the respondent and frankly the university to acknowledge what has occurred. Maybe there's an impact on both the complainant and the respondent. The difference is to acknowledge what happened. The apology, and maybe that's more for the respondent than anyone, is to say, I am sorry for what happened. I am going to take responsibility. Maybe it's I've signed up for an AA class. I'm going to make this right. This is what I'm willing to do. But even when someone says, I'm sorry what happened, and we're going to work hard to resolve this today, I think that is a powerful message to send at the beginning of the mediation. And then we can kind of turn to the more creative type back and forth positions and come up with a solution. Next slide, please. I think it's helpful to not just make offers and make demands, but to be able to be in a position to provide rationale. We are now going to move from A to B, and the reason is this. Rationale provides a better understanding to the other parties of why you're moving the way you're moving, not I'm just negotiating and trading positions. There are times, by the way, where parties get stuck. And there are techniques to break impasse. And sometimes, even though the mediator is not a decision maker, the mediator may make a proposal that says something like, it seems to me that the complainant is here and the respondent is here. The university may be willing to be here. How do we get this across the finish line? And a mediator may make a proposal to all the parties. And that is usually one of the last tools in our toolbox as mediators. And that is where it is a triple blind proposal. And what I mean by that is the only way that the three parties will know there is a deal is if all three agree. If the complainant does not agree, but the school agrees to my proposal, I'll never share that the school agreed with either of the parties. It's only when all three parties acknowledge that there was a deal. And in a three-way, three-party mediation, the school may agree, and you'll never know whether one of the other two sides agreed or maybe they both disagreed. All you know is not all of them agreed. That sometimes is a stepping stone to new offers and demands. And again, our goal as mediators, it's not about what the solution is. It is to find a resolution that meets the parties' needs. And our goal is to reach resolution. There are some that have said that I'm kind of the junkyard dog, always looking to get the settlement. But that's what we're invested in doing, is to resolve this so that all three of the parties can close the page on that chapter and be forward looking. The mediation process allows all of the parties to move from looking backward at what happened to be able to turn the page and look forward. That's what allows the solution to strengthen the relationships between the three parties. Students, school, I assume it could also be disputes between employees, faculty, and the school itself. Next slide, please. So I acknowledge that everybody gets to play the mediator. And that's fine. You can hold back on some information. Truth telling is helpful. But I also appreciate that sometimes people will tell me, I think about a civil case that I had, which was a trucking case. And the plaintiff just said, Rob, there's no way my client will take less than $2 million. He started at 5, he was at 2.5. No way he'll ever take less than 2. The defense was at 700. Rob, there's no way we'll ever pay more than $1 million. No way. Case settled about a week later at $1,307,550. It's a process. The other thing I think is important is while mediators are facilitating our opinions, don't always come into play. We're facilitating conversations, but you can ask your mediator for an opinion. Based on your experience, do you think, fill in the blank? That's the benefit of having experienced mediators serving in this role. Next slide, please. Perhaps the thing that folks need to appreciate is that not all settlements happen at the mediation. Pat, the last one we had, the two of us settled the week after we were here in the office. I like to have people at the end of the day have what I call a soft landing. And what I mean by that is it's not taking your laptops and throwing stuff in your briefcases or backpacks and storming out. We've reached as far as we can go today. We'll follow up. The mediators will certainly follow up with the parties. And even though it doesn't settle the day of, oftentimes we will resolve the dispute in the day or two or perhaps week after, and it comes to an agreement. The key about resolving at the mediation is you have the opportunity to fill out a mediated settlement agreement or a terms sheet. That is, it has all the material terms of what you agreed to, and most importantly, it's signed by each of the parties. That is helpful. Then perhaps the lawyers may want to draft a more formal settlement and release agreement, but at the end of the day, you have something that would be enforceable so that someone's not having cold feet the next day. Those are some thoughts that I had. And the last slide are questions. Pat, I'm sure I missed a few things.
You did a great job, Rob, for you covered a lot of ground in a relatively short period of time, and we appreciate that. There are some questions on the chat box that you might take a look at. In particular, I'd like to reference, there's a question about posting these materials on the school's website, which is one of the requirements for training materials. Now, I'd like to talk with Rob on this because these are his materials and they're copyrighted. I don't see an issue with them being posted, but not for republication or public use. Obviously, if they're on the website, they're available to students and others. But I would like to discuss that with Rob, and Adrian will send out a follow-up email to all of the registrants today as to that question. Rob, there are a couple of items asking about confidentiality in the context of mediation. If you'd like to take a glance at those, I'd like to, while you're looking at those, I'd like to circle back. There was a question on the obligation of a university in providing an advisor And that does not have to be an attorney, but I'd like to comment on that, that in looking at the litigation that focuses on Title IX and colleges' responses to both complainants and respondents, a common theme in many of those cases is the school's violation of due process. And I think that a potential target area here is if a school focuses on the cost of an advisor rather than the qualifications of the advisor, that is an opportunity for the represented party to later bring a claim saying that the school did not adequately provide them with competent advice. This shows up in litigation all of the time, particularly in the criminal aspect, where defendants who are convicted will file an appeal or file a new suit alleging inadequate counsel. That's really not discussed within the regulations nor the preamble, but I would suggest that all of you, regardless of your role in the Title IX process, consider this in the context of risk management and whether this is an issue that your school council should weigh in on as to the merits of the advisor that's designated to represent a party in a hearing. So that's just my thought.
Pat, I did see the question about whether the Title IX decision maker could be present during the mediation and disregard what they heard. Let me say this and make sure if I misspoke as I presented, I apologize. The mediation will not include whoever the decision maker would be at the ultimate hearing if the case doesn't settle. It is just the three parties, the complainant, the respondent, the school, and their representatives, and that's all. And what happened during that process, certainly by the typical agreement to mediate that I have been using now for many, many years, the parties know up front that what happens in mediation stays in mediation, and that the offers that went back and forth during mediation could not be presented if the case is not settled, could not be presented at the hearing with the Title IX decision maker. So confidentiality would stay within the mediation itself. I'm trying to see, Pat, about other items.
You can see these questions, right, Rob?
Yes, okay. Q&A. So there was a couple questions about restorative justice model and whether that could be used in lieu of mediation or arbitration. In the commentary for the regs, it does speak to use of the restorative justice model in addition to mediation and arbitration. I can't tell you the exact page, but the discussion of the informal process starts at page 1363 of the regulations, and it does speak to the various forms of process. Restorative justice starts on 1386, and yes, that process can be used in lieu of mediation or arbitration. The last thing, someone did ask, where does that fit in the continuum? Frankly, I think it's closer to the negotiation side than the next step in the mediation side, because it's a dialogue between the school as the community and then the two parties, and you're looking to right the wrong and have an acknowledgement of the harm that was incurred. And so it's closer to the negotiation side when looking at that continuum. Pat, anything else I've missed?
There is a question as to whether the Title IX coordinator can serve as a mediator. There is nothing in the regulations that prohibits that, as there is the prohibition on the mediator serving as decision maker, or the Title IX coordinator serving as decision maker. The regulations do provide, though, that anyone who is engaged to facilitate informal resolution is to be trained in the background of Title IX and sexual assault. And I've looked through the preamble, Rob, and I don't recall anything specifically prohibiting the Title IX coordinator from serving in the mediator role. I think that for the same reason that there are comments in the preamble about the Title IX coordinator not serving as the decision maker because of their multifaceted role in the informal process and the formal process, it may make it difficult for the coordinator to serve in the mediator role.
I think it would create potential conflicts of interest because as the Title IX coordinator, you are serving one role on behalf of the university, and the university is a party to the mediation. So I think they could serve a role as the advisor, but the mediator is someone who is a neutral third party that does not have connections to any of the three parties. And it's because of that neutrality that gives a sense to all the parties to have confidence that they're really looking out for one thing, and that's just reaching a resolution, whatever it might be.
It is 2:01. We'll try to stay on time and wrap up today. I think there are a couple of questions maybe in the chat box. We'll try to respond to those later today or tomorrow. We will follow up on the question on posting the materials on everyone's website. And please keep in mind our training program, which is scheduled for August 6th and 7th, as Adrian said. We will have materials coming out shortly with more detailed information on the agenda and speakers for that program. Thank you all for your time today. Rob, thank you very much for sharing your time with us. Excellent presentation. And everyone have a wonderful day. Thank you.
Thank you all. Pat, thank you, and thanks for attending, everyone.